smear Israel's move to shut down Palestinian human rights work, you're in the right place. People are just starting to file in. We're going to give this a minute or so for people to join us, and then we'll get started. So please sit tight. To say again, if you are joining us for the webinar this morning on the terrorism smear, Israel's move to shut down Palestinian human rights work, you are in the right place. We are now live on Facebook. We are just letting a few more people enter the Zoom room. We will get started in about 30 seconds. So thank you. All right, we're going to get started. Hello and welcome. I'm Lara Friedman. I'm the president of the Foundation for Middle East Peace. Welcome to today's conversation, the terrorism smear, Israel's move to shut down Palestinian human rights work. Some quick housekeeping before we get started. As always, the format for this webinar will be a discussion between the panelists and myself. We will end promptly at 12:45 p.m. We are being recorded and live streamed on Facebook, so welcome to everyone both on Zoom and on Facebook. I have my own questions. In addition to my questions, I welcome questions from our audience. If you're on Zoom, you can put those questions into the question Q&A box. Don't put them in the chat box. I won't see them, and I'll keep an eye on that throughout the discussion, the question box. As far as the chat box, you should be keeping an eye on the chat box because my colleagues behind the scenes of the foundation will be putting useful links and information into that box throughout the discussion. But again, don't send me anything on that, I won't see it. And last, we have enabled closed captioning for people who prefer or need to read the discussion and follow it that way. So to get started, just a very brief background, as probably everyone here knows, in October, the Israeli government declared 6 Palestinian human rights groups to be terror organizations, a designation that criminalizes their work under Israeli law and enables Israel to seize assets, arrest staff, prohibit funding, punish public expressions of support and solidarity, etc. With this terror designation, the Israeli government has in effect escalated what has been a long-time effort to crush Palestinian organizations that document Israeli ongoing violations of Palestinian human rights and who seek to hold Israel accountable. So that's what we're going to be talking about today. And I am very happy and we are deeply honored to have with us leading human rights and civil rights activists. Their full bios are available on our website. I'll introduce them very briefly here. I want to start with Jamil Dakwar. Jamil is the director of the American Civil Liberty Union's Human Rights Program. In this role, Jamil advocates before the US government on human rights issues with a particular focus on the domestic implementation of US human rights obligations. Before joining the ACLU in 2004, he worked at Human Rights Watch, where he conducted research, advocated, and published reports on issues of torture and detention in Egypt, Morocco, Israel, and the occupied Palestinian territory. And previous to that, he was a senior attorney at Adalah, where he filed and argued human rights cases before Israeli courts and advocated before international forums. That's Jamil. So second, so for reasons beyond his control, Adalah's Hassan Jabarin, who was scheduled to take part in this webinar, is unable to participate, and we are very sorry and hope to have him another time soon. In his place, we are very pleased to welcome one of his Adalah colleagues, Rabea Eghbariah. Rabea is a human rights lawyer with Adalah Legal Center in Haifa and a doctoral candidate at Harvard Law School. He has written extensively about Palestinians and Israeli law and argued several Supreme Court cases for Palestinian rights, including cases involving the 2016 anti-terror legislation, which is really at the heart of what we're talking about today. And finally, we are very honored to have with us Dima Khalidi. Dima is the founder and director of Palestine Legal and Cooperating Counsel with the Center for Constitutional Rights, CCR. Dima oversees Palestine Legal's vast array of legal and advocacy work to protect people speaking out for Palestinian rights from attacks on their civil and constitutional rights. And again, if you want more information, bios, links, details, their work, check our website. So diving right in, and we have a lot to cover. Rabea, I want to start with you. Speaking in your capacity as an authority on Israel's legal system, can you first talk a bit about how these designations that took place a week ago today, how are they possible under Israel's 2016 Antiterror Law? And what do these designations mean under Israeli law for the 6 NGOs in concrete terms?
Thank you, Laura, and thank you everybody for having this important event. I will delve right directly into your question, Laura, and say that, well, if we want to understand these designations, obviously there is two important contexts. As a matter of law, the 2016 Antiterror Law that Israeli Knesset enacted is the legal framework that is at play here. And this legal framework is problematic in itself. It was enacted in 2016 as an aim to replace legislation or legal corpus that was still in force from the British colonial period, from the British Mandate, which is actually part of it are still used both in Israel proper and in the West Bank, even after the enactment of this anti-terror law. But what happened with the enactment of this law is that it gave extensive powers to the executive branch, particularly, and to the prosecution and to the courts to smear many legitimate claims under the pretext of anti-terrorism. So the law broadened the authority of Israel to consider certain acts or certain expressions as terror related. So this is the general framework. We still have cases just coming up in the last couple of years that are using this law, and we are still challenging the use of this authority, in particular against political leaders, Palestinian citizens who are political leaders who are charged according to this legislation with charges of incitement in particular, which is an overbroad interpretation of what is previously could have, even according to the Supreme Court of Israel, been illegitimate speech. So this is the general framework. It is obviously a dangerous framework. It is obviously an unprecedented framework that is cracking down on dissent, on political views, and on Palestinians in particular. Now, within this context, the designation of the 6 Palestinian organizations came in accordance with this law and the provisions it provides to consider these civil society organizations as quote-unquote terror organizations. The law works territorially, right? So it is legislated by the Knesset, the Israeli parliament. So ostensibly, it does not apply directly to the West Bank, where these organizations are founded and operate their offices. But, and there's a huge but, although the law applies territorially, it has extraterritorial consequences, and it still pertains and has legal force to extraterritorial entities such as the 6 organizations we're talking about, but also beyond that. And what I mean, so just to make it clear, the military, who is the authority, the legal authority in the West Bank, has not issued an order that designates these organizations as terrorist organizations. So supposedly this order or this designation applies only to Israeli law within the green line, within Israel proper, but this can have huge ramifications for considering these organizations as terror organizations according to Israeli law. And I will give examples. So first of all, we know that there is a mishmash between the legal situation in Israel and according to Israeli law and to the law pertaining to the West Bank, Gaza, East Jerusalem, right? So there is different legal framework that should apply, but there is a huge overlap, and the actors are still the same actors that can employ their discretion based on the same consideration, and this has happened before. Now, the designation of the 6 organizations as terror organizations according to Israeli law can have consequences on movement of members of these organizations, namely if anybody wants to cross the borders or go to Jordan, for example, or enter for some reason Jerusalem, this can supposedly the law becomes territorially, the jurisdiction of the law applies. But beyond that, this can become a pretext to arrest and detain people who are involved in these organizations under the pretext of administrative detention. Beyond that, it still has immediate effect on citizens of Israel itself, including obviously Palestinian citizens who might be held or charged in pursuance of the glorification or incitement provisions, which basically can be sometimes a Facebook post or an online post. And we have had cases as such in Adalah with, for example, Rabea Eghbariah, who's a political leader of the Abna al-Balad movement, and Kamal Khatib as well, who are all prominent political leaders of the Palestinian citizens in Israel. So we can see that this also may have consequences that are directly about speech, about movement, about administrative detention. But beyond that, obviously, the main point of this designation is to stop the funds, right? So, and this is articulated first when I saw this designation, I saw Diala Shammas tweet about this, and I thought this was brilliant articulation. The idea of using anti-terror legislation is to stop after years and years, and we can talk more about that later, but after years of trying to target civil society and these particular organizations, we are seeing that Israel is resorting to its national legislation and using this 2016 extensive measures to basically try to cut foreign funds for these organizations because banks simply won't take the risks anymore.
Thanks. And we're going to delve into a lot of things you mentioned. For folks who didn't see news this morning, that last piece that Rabea is talking about, we've already seen this now starting. There's a Finnish NGO which announced they were cutting off funding to one of the groups. In the statement they made clear that they have found no evidence that any money is being misused or going to terror, and they like the organization, but that because of the banking implications, they are forced to cease the funding or it will end up hurting them in their work worldwide, which is, I would argue, exactly what the playbook is here. I want to take this in a slightly different direction. Jamil, can you, let's go back. You tweeted a while ago about the fact that the Israeli government escalation against both the Palestinian and Israeli human rights groups really started with the Goldstone Report in 2009. Can you talk a little bit about that? I'm not sure if everyone here is old enough to remember the Goldstone Report. I remember it like it was yesterday. Can you give us a little background on that? And can you give us background on the punitive and restrictive measures that the Israeli government has taken against civil society in the wake of that report and in the wake of their outrage at the role of human rights groups in that report? And you know, to what extent, if you're comfortable, can you talk about how you see the timing of this effort to label the 6 NGOs as terrorist groups? You know, looking at the Goldstone Report as a precedent, I mean, it has been suggested that the timing is not unlinked to the war crimes investigation before the ICC. If you feel comfortable weighing in on that too.
Absolutely. First, thank you very much for organizing this webinar. I'm very pleased and honored to be with my colleagues and friends, Rabea and Dima. I wanted to first maybe continue where Rabea left off and to say that under Israeli military law, virtually all Palestinian political parties and movements are considered illegal. And has even despite the so-called peace agreements and peace processes, there hasn't been change in terms of the change of the classification of Palestinian groups that are political groups active in. So there's always been restrictions on political activism, and especially and including on very basic rights like freedom of assembly rights in the West Bank. Under Israeli military law is virtually non-existent. It's illegal. It doesn't. You cannot do that without violating military law. in addition to that, Israel resorted to the illegal frame of association, turning and describing and labeling associations that are linked to political parties, not only in the West Bank and Gaza, but we have a history of Israel's doing so even inside Israel. There's a long history that we don't have the time to go into, for example, of banning Al-Ard movement and associations linked to Al-Ard as illegal associations, using some of the mandate colonial era laws that allowed the Minister of Interior and subsequently other ministries to put place restrictions and banning altogether these organizations. So there's a long history of banning organizations, whether they are in the political realm or even active in the cultural realm, in the civil society realm more. So the frame of anti-terrorism frame is obviously relatively new, and particularly comes from and escalated after 9/11, as was mentioned earlier. And I think it's a much more comfortable frame for the Israeli government to use in order to crack down on dissent more broadly and to derail the resources, drain and derail the efforts and resources of any Palestinian legitimate human rights organizations, but also more broadly. So when you look back and when this escalation, I mean, it's always been attacks and restrictions on all sorts of restrictions, restrictions of movement, ability to really form any legitimate activism against the Israeli occupation. But the escalation, in my view, really you can trace it back to the Goldstone Report. And the Goldstone Report that is named after the former Justice of South African Constitutional Court, who headed a United Nations fact-finding mission that looked into possible war crimes that were committed in the context of the war in Gaza in 2008, 2009, Operation Cast Lead, which resulted in over 1,300 Palestinians killed, 13 Palestinian civilians on the Israeli side. And that was the first time that the UN Human Rights Council mandates a commission that has not only directing, by the way, the mandate to investigate war crimes by Israel, but also by Palestinian armed groups that were participating in that particular military operations, or responding to Israeli military operations. And that was the first time that you have a very serious report, very serious investigation. It's not a full-fledged investigation because they didn't have even access to the Gaza Strip, and they didn't have ability to get access, and there was no cooperation from the Israeli side. But there was a first serious effort that where Israeli violations of international humanitarian law were documented, including case study, including specific cases where there was a clear violations of the laws of armed conflict, and with clear recommendations and findings that were brought to the Human Rights Council and called for more accountability and referring the case to international criminal responsibility, particularly as there was more and more cases and more awareness around the International Criminal Court. Of course, by that time, Palestine, or Palestinian Authority, was not part of the ICC. So it was almost very, very difficult to bring, unless there's a referral from the Security Council, to bring a case like this to the ICC. And yet it was clear what the writing was on the wall. But that is, it was clear that the Israeli government, for the first time, there was a very credible commission of inquiry. Obviously, Justice Goldstone, after pressure on him personally, retracted some of the findings, but the commission's report stands, and its conclusion, I think, stand without doubt, because the other members did not, walk back from the recommendations. But from that point, you see that both the Israeli government, as well as NGOs, both Israeli NGOs and international organizations, as well as US-based organizations, launching attacks against not only the Goldstone Report as such and undermining its credibility and the importance of its finding, but launching a smear attack against the organizations that were participated and provided testimonies to the Goldstone Report. At least 2 of the organizations that were designated as terrorists participated in that, Damir and Al-Haq. And you would see that NGO Monitor, their first press release on the Goldstone Report from September 2009, specifically targeted those NGOs as the political NGOs. So there's a clear identification of these, at least 2 of the 6 at that time, that these were targeted and they're funded by the Swedish government and other European government. From there, there were more laws in Israel, as well as attacks on both Palestinian and Israeli NGOs, limiting, for example, their lobbying on violations of Israel's violation of human rights, with passage of 2016 NGO law that would put restrictions on that. Passage of other restrictions on a movement that was placed on some of the activists. Shahwan Jabarin, for example, was banned from traveling abroad in 2008. And so the 2 things that happened is that there's a clear indication that as Israel launched other military campaigns on Gaza, again in 2012 and again in 2014, and most recently in May of this year, there was a growing effort and more serious attempts to hold Israel accountable at the international level. We have the UN Human Rights Council establishing a new database on illegal settlements that was a result of many advocacy organizations, including Al-Haq, particularly Al-Haq because they have a special program on business and human rights. And you have, on the other hand, advocacy in the context of the ICC. And so Israel and its supporters started to use all kinds of ways, and I saw that the security and charity report was posted in the chat, in order to undermine those efforts and to smear and to brand both organizations like Al-Haq, Damir, and DCI Palestine and others as linked to terrorism. So to diminish their credibility, to defund them, to accuse them of baseless claims that they were tied to terrorism. At the same time, taking the effort of blocking any attempts to engage in boycotts, particularly with the passage again in 2011 in Israel, the anti-boycott law that placed civil lawsuits liability for people who would call to boycott, and that boycott would materialize in some way. And as well as other attempts at, for example, banning Israeli human rights organizations from speaking to students, high school students and schools about human rights violations in the occupied territory. So there was a whole host of ways that the Israeli government, both by legislation, by measures, creating a whole ministry of strategic affairs that was in 2015, that was focused on a coordinating effort to fight what they call delegitimization of Israel, boycotting Israel, and attacking and basically holding it accountable before international bodies. So from there, it is clear that we get to the point where the ICC has taken up the investigation in not only in the context of Gaza, but also more broadly in the context of illegal settlements and potentially the crime of apartheid and persecution. So you have international organizations like Human Rights Watch coming up with a serious report documenting the fact that Israel has been engaged in committing the crime, the crimes against humanity of apartheid and persecution, and while at the same time the ICC investigation is moving forward, clearing hurdles and extensive pressure from many countries that are allied of the US or Israel to stop and to block that investigation from moving forward. 3 of the 6 organizations participated actively in providing materials and evidence and information to the chief prosecutor of the ICC. So there is a direct link between their effort, not only in monitoring and documenting human rights locally, something that the Israeli government would not be making that much of an issue with, because as long as they're not crossing the line, as we heard from the leaders of the organization last week, once you cross that line, the line is when you place personal liability, criminal liability against Israeli officials, Israeli military leaders for commission of war crimes and crimes against humanity, or making an effective contribution to the effort to boycott Israel and to isolate Israel and sanction Israel, something that DCI Palestine has worked extensively in the last few years by bringing, for the first time, or helping to bring, working with members of Congress and informing them and educating them about the need to have conditionality. So all of these together made it, I think, opportune moment for the Israeli government to say, we could have a case against those six that would send multiple messages. Message against holding Israel accountable in international fora, messages to the funders, messages to politicians and policymakers around, particularly in the United States and in Europe, and also messages to Israeli civil society organizations, including international human rights organizations that have joined the effort to hold Israel accountable. Because before the Human Rights Watch report around the issue of apartheid, it was really limited to local national Palestinian human rights organizations. Now, it appears that this is becoming a very credible and imminent danger for Israeli officials and for Israel to be, for the first time, facing consequences. So I think that is why we see this case culminating and becoming a point where if it's allowed, if this move is allowed to go without consequences, it will be really quite difficult to resist or to push back against anything that Israel would do in the context of if it's military occupation of the West Bank, East Jerusalem, and Gaza. Thank you.
Thank you. And we're going to dig into a lot of the things that you raised. We're not putting any links in the chat, I don't think, to NGO Monitor. But for folks who hear about this and think this designation came out of nowhere, it's useful to go back to really the Goldstone period on the NGO Monitor website, because what I think is quite instructive is the attack we saw last week is clearly aligned with the attacks we started seeing back in 2006. It's just an escalation of tactics. In 2006, the attack wasn't saying, oh, these are terrorist groups. It was saying they're delegitimizers, or in subsequent years saying, oh, they BDS, that means they're anti-Semitic. The attacks have been the same over and over and over. It's just the framing. Each time a framing doesn't work, it's like they adopt a new one. And the terrorist framing seems to be the one that they believe will be the knockout punch. Speaking of knockout punch, so Dima, I want to turn to you, and I want you to talk about this from a US and international legal perspective. You're welcome to address anything that's been talked about already, but also specifically, I've had people ask me, explain to me legally how this works, that Israel is alleging terrorist ties, ostensibly, organizations aren't people, they're ostensibly alleging ties or actions that support terror from people within organizations, and yet they're deeming entire organizations to be terrorist organizations. I said to someone, it's like if during the Trump administration, his Justice Department said, oh, we found 4 people at Planned Parenthood who are somehow involved in the mafia, so we're going to shut down all of Planned Parenthood as an illegal criminal enterprise. How does that hold up under US law, under international law, under any concept of normal, due process, jurisprudence, rule of law?
Well, thanks again, Laura, and good to be with you all. I think we have to connect what Israel is doing with the broader post, also pre, but especially post 9/11 war on terror, the entire terrorism regime, counterterrorism regime that has been constructed. And if you look at how what's happening in the US, what has happened in the US over the last couple of decades, actually this practice of shutting down entire organizations is very familiar. Just look at the Holy Land Foundation case, where before heads of that organization were criminally prosecuted, the organization itself was designated by the US government. This was a massive humanitarian organization. And along with a couple of others, it was completely shut down. Its finances were shut down, et cetera, after 9/11, of course. And now those who headed those organizations are still behind bars over nearly 2 decades later. So we have to be shocked to hear about the draconian, the politically motivated counterterrorism law that Israel has. And we have to be equally shocked by our own counterterrorism laws and the jurisprudence that has grown around them. In the US, it's exceedingly difficult to challenge designations as it is in Israel. These designations often rely on secret evidence. Courts give huge deference to government agencies that make these designations. So there have been very few designations that have been successfully challenged. And again, the implications are huge, not only the freezing of funds, but the opening the door to surveillance, government surveillance, and individual criminal liability. This notion that Israel is unique in using these kinds of strategies, these legal strategies, is just not true. And in fact, it has imported so much of its counterterrorism strategies into the US and globally. We've seen terrorism prosecutions here completely eviscerate due process protections. They've resulted in some of the most Kafkaesque trials. They've relied on the same kind of guilt by multiple degrees of association that Israel relies on. And we see that the evidence for these trials is actually provided by Israel. Israeli intelligence agents are allowed to testify anonymously in US courts, so that defendants can't challenge their testimony. These are undermining fundamental constitutional due process protections, right? Courtrooms have been close to the public. Evidence is deemed classified so that defendants can't access it. In one case that I worked on when I was a law student here in Chicago, the case of Mohammed Salah, it was almost an Israeli-style military tribunal in a US court. And that's because the Israeli government was in fact constructing the entire case and providing all of the evidence for the case. And the US court responded to that and to the Israel's pleas to keep the information confidential, et cetera. So, this shouldn't be a surprise. The US has proved to be a critical ally to Israel in this respect as well. And it's in the US's interest. It's bankrolled and is complicit in Israel's crimes. And so it's gone along with anything that appears to justify them, and the US's own war on terror. It knows that allowing Israel to be accountable for the actions it's taken to achieve Israel's own settler colonial project would mean that the US has to face accountability for its own original sins of genocide and slavery. So this is all to say that the entire counterterrorism regime in Israel here and just globally really undermines due process because it is reliant on secret evidence, and it's ultimately a political tool. These are political tools that Israel has helped to develop in the United States as well. That's clear from what Rabea and Jamil have said. This is about these organizations' work to expose Israel's crimes and hold it accountable. And in the same way that people here have been targeted for sending humanitarian aid, for all kinds of advocacy, we're seeing that those who are most effective in exposing and trying to hold Israel accountable are the ones that are being targeted. So all of the rule of law principles in the world are being buried here and undermined and eviscerated. as part of this strategy.
Thanks, Dima. And I think a lot of people probably are unaware of the degree to which post 9/11 anti-terror laws were at least initially used first and foremost against Palestinians in the United States, not against anything to do with Al-Qaeda or the actual, 9/11 activities. They were turned into a weapon against Palestinian American organizations very quickly. And that's a subject for a whole different webinar, but it's certainly related. Rabea, I want to come back to you and sort of picking up on where Dima left off, which is not the most hopeful place in terms of the ability to challenge or litigate the charges in some way. Yesterday there were two big articles that came out, one in Haaretz, one that was in 972 in The Intercept. And these two articles shined a light on what is at least some of the so-called evidence that the government of Israel is apparently now sharing in Washington. And we know this because they previously shared this evidence in Europe, and the documents apparently are circulating. The headline of the article in 972 Intercept, I'll read it. It was, "Secret Israeli document offers no proof to justify terror label for Palestinian groups." Can you talk to us about this question of evidence? What is this evidence, as far as you understand it, that Israel is relying on or has relied on, and the legal basis in the anti-terror law, which enables them to use evidence which apparently the Europeans have now repeatedly found to be utterly uncompelling, to categorize things like, according to the article, a Palestinian dance troupe or women's empowerment training as a form of terrorism or support for terrorism.
Yes, thank you, Laura, for this question, because I think it is an opportunity to say something about what this designation is doing already. It is putting these organizations, ourselves included as lawyers or civil society people, in a defense mode, right? It is already forcing, the power of this designation, regardless of evidence, is that now we have to start justifying that these organizations are proved that these organizations are not terrorist organizations. And this is part of the scheme. This is part of what this designation is intended to achieve. It's a discursive power that shifts the burden on these organizations now to go to international funder and states and etc. and try to say, wait, there is no evidence, in fact. And that's really the situation. No evidence has been provided. We do not know anything about the evidence besides what has been published, both by media, but also in the designation itself. And it is a good opportunity to quote one of the designations. It's a very short paragraph that the designations themselves, which is the order that designates these organizations as terrorists, it's issued by the Israeli Minister of Defense, Benny Gantz. And I'm quoting from the cause of designation for Al-Haq, which is pretty similar to all other organizations. It's a one paragraph kind of reason, right? And here it goes. Al-Haq organization was established in 1979 and became an arm of the Popular Front for the Liberation of Palestine, the PFLP, which has previously been designated as terrorist. Second, the organization is based in Ramallah. The declared Al-Haq activity is in the field of human rights protection. However, in practice, it is engaged on behalf of the Popular Front in promotion of steps against Israel in the international arena, which constitutes part of the terror organization's struggle against Israel. Now, I think this is sufficient to understand that Israel has become so blind to its own use of the terrorism that it's basically saying what we consider as terrorism is promotion of steps against Israel in the international arena. This can include, in fact, legitimate steps, legal steps to enforce international law. We know that Al-Haq is involved in the procedures in the ICC, for example, against the investigation against Israel in the ICC. So this is pretty much the framework, or what we know from the designation about why they're considered, according to the declaration itself, as terrorist organizations. Neither the minister Gantz nor any other public official in Israel itself came up officially and shared any shred of information about the evidence that is at core. We just saw in the last week the Intercept article, and that reveals this dossier, but the allegations are still very much cryptic. All allegations are based, even according to these revelations, basically, or the Intercept article. You know, we are seeing that these are the evidence, quote unquote, that the designation is based on, that was presented to diplomats, to foreign funders, or to ministries across the world, is based on 4 testimonies collected from workers of a different organization, which itself, the Health Work Committees, which itself was designated as unlawful, which is a distinction from terrorist according to the law. So this is part of, you know, the Health Committees is a 7th organization designated as unlawful organization in January already, and parts of its general director Shada Audi is placed under administrative detention since, and with no evidence. The idea of administrative detention is, again, that there is no evidence, no concrete evidence that can be sufficient to instate or to issue a criminal process. And we know that every 6 months, these administrative detention can be renewed, etc. So basically, the idea is that according even to the Intercept revelation, these quote unquote evidence, which is basically the testimonies of 2 particular workers that used to work prior to that in the health worker committees, which provide help.
Just to be clear, when you say testimonies, you mean confessions under Israel's Security Service interrogation?
Exactly. That's what I was heading towards, saying that even these testimonies or these confessions are part of an investigation that included torture, according to the lawyers of these people as well. And again, that again, I think that it's not productive to start going through the details of it. I think we should say that we know really nothing, and that no evidence has been presented. Even this quote unquote evidence that Israel has been going around and presenting to foreign governments, you know, including the Dutch and Spanish and other ministers, the Dutch and Belgium, denied that this evidence constitutes any meaningful evidence that pertains to these organizations. So we are just seeing that basically declaring these organizations based on testimonies that are, or based on confessions that are extracted by the way of torture, a practice that has been ostensibly unlawful under Israeli law, but since 1998, when the Supreme Court said that torture is supposedly unlawful, we know that the practice of torture is very much evident in security investigations. And this has been really came to a climax, I think, with the Tbesh case, for those of you lawyers who are following the corpus of Israeli law, which pretty much says, the Supreme Court said, in a case where there were concrete evidence of torture, the Supreme Court dismissed the case and said, opened a wide door for continuing with the practice of torture. Now, this practice of torture is also comes on top of denying any lawyer meeting with a lawyer or consultation during the investigation. So this is the evidence we're relying on, quote unquote. And I'm satirizing it because we have to satirize it, because we should be aware that we should not be we should not fall into this role of defensive mode to start assuming that there is evidence when no evidence has actually been presented.
Yeah, no, that's a really powerful point. I think going back to the satirizing, one of the things that is striking in reading these articles, it's related to what you read to us about the Al-Haq indictment, which is the definition of terrorist activities, at least by Israel's definition, has now been expanded so broadly that it includes things that are clearly not terrorism by any other definition. At this point, it almost seems like everything is terrorism. And according at least to the article in the Intercept, the confessions that they're relying on are actually being not fully, there's what the confession about the Dub case where they actually cut it off. They cut off the person in mid-sentence. So they basically have someone confessing that these organizations are supporting PFLP activities, but then the journalist got the full transcript of the confession, and then it talks about what those activities are, and they include dance recitals. I mean, it's really, it's quite striking. It satirizes itself in a sense if you look at the details.
Yeah, I just want to add, Lara, before that we have seen cases, in fact, that civilian activity has been criminalized under the pretext of anti-terrorism, in particular with Gaza. So there were cases that went again to the Israeli Supreme Court where there was no dispute that the activity, it was even commerce. You know, Palestinian activity, daily life can be criminalized under the pretext of this legislation, under the pretext of this 2016 law that expands the definition of terrorism to include daily activities that are, even according to the Israeli Supreme Court, are legitimate, but can still be considered terrorist. For example, and with this, I'll wrap up on this idea to just understand how even civilian activities in nature, and that there is no claim that it constitutes any terror. So for example, we know that providing charity or providing any arms of charity slash civil service to the community can still be counted as terrorist or charged for terrorist provisions if it is somehow related to these organizations that are declared terrorist. So this is, in US terms, it's quote unquote material support, right? That we know that it's like an overbroad interpretation of this meaning.
Thank you. And Dima, I want to turn to you and relating to this last question of what is terrorism and evidence, because they're related to what you were talking about before. There seems to almost be a really, almost like tautology here. It's like, you know, they're terrorist organizations because we say their activities are terrorist, and now that we've declared them terrorist, all their activities and support for these activities is by definition support for terrorism. It's again, that sort of recursive thing. Can you talk about how that figures in with the US side of things? I'm thinking about some of the lawfare cases where, for instance, the Carter Center was charged with material support in a SLAPP suit for providing, and in the lawsuit, I remember you and I both saw it, the word they circled on a picture, they provided fruit, water, and cookies at a public event, and that was a charge of material support for terror. And can you also talk from a US legal standpoint about this whole idea of cases that rely almost entirely on confessions from people who are facing charges themselves, sort of unsubstantiated confessions as being the core of the indictments?
Yeah, I mean, what Rabea was starting to say about U.S. law is really what's at issue here. And under U.S. laws, our provisions for material support for terrorism basically allow the criminalization of speech, of advocacy. So in a Supreme Court decision, Humanitarian Law Project decision several years ago, we saw that providing human rights training to a designated organization becomes can be material support for terrorism. And so, this is something that that Israel has trying to push the boundaries on in order to encompass, even speech, even advocacy for Palestinian rights. If you can make whatever tenuous associations with a designated organization, that's all you really need in order to make these claims. So it's a very dangerous and it's a dangerous regime that we have here, and it's something that Israel has been exploiting and is clearly trying to exploit in this instance. And when we're talking about evidence, I think we've seen efforts to use material support claims in civil cases, right? So an organization, an advocacy organization like the US Campaign for Palestinian Rights was sued based on 6 degrees of separation with Hamas, right? So you can make that link in any which way, and it sounds absurd, and yet U.S. law allows for this kind of guilt by association. And the case has been dismissed; it's being appealed, of course, but in the end, the point is not necessarily what evidence do you have, it's can you make this organization radioactive? Can you suck their resources dry? Can you intimidate other people from engaging on this issue? And that's what we really have to combat here. We have to combat the chilling effect that these kinds of accusations are creating all over the place. And the intention is to isolate. The intention is to distract us from the real issues, distract us from trying to get accountability for Israel's own crimes. In terms of just tortured evidence, just to make the point, again, the extent to which Israel's efforts have been adopted and really used in U.S. courts is terrifying in many ways. There are provisions under U.S. law that to be admissible in court, a confession has to be voluntary. So technically, a tortured confession, like we're talking about in this, the dossier of evidence that Israel has created, should be inadmissible. And yet we've seen in several cases tortured confessions from provided by Israel admitted in US courts. Again, based on secret evidence, based on testimony of disguised Israeli agents in US courts. Rasmea Audi's case was also hinged on a tortured confession, right? When she was charged for an immigration offense. So, the fact is, when it comes to these terrorism issues, the evidence doesn't matter anymore. And these cases are all about guilt by association. They're political, and whatever it takes to secure convictions, to make examples out of people is allowed in courts, despite all of our due process protections. So I think that what we have to combat here and in the Palestine context is any credit to Israeli designations, to what the Israeli government says about our civil society groups that are engaged in advocacy, speech, human rights work, and that is where we have to focus on continuing on protecting our own people who are engaged in this work, and also tackling this broader problem of the counterterrorism regime, of the war on terror regime, because that's what has allowed this kind of targeting of civil society to persist.
Thanks. And listening to your answer, I'm thinking about what Rabea said in this idea of you're guilty until proven innocent, must prove yourself innocent. And it's come up a couple times in Q&A, the idea that there's something here that feels very reminiscent of sort of the Red Scare and McCarthyism. I was joking with someone that it's sort of like they want every Palestinian to stand up and swear, are you now or have you ever been a supporter of, as if that is like the starting point to being considered kosher, to have any political views or be engaged politically in nonviolent activism of any kind, which is really pretty appalling. Jamil, turning to you, you're here, this is something I know you think about a lot. Can you talk about the response of the Biden administration that you've seen so far to this decision, and how you think they're going to act? They've asked ostensibly for clarifications. And again, we don't know for sure what they're looking at, if it's exactly the same as what the Europeans got and rejected, or if it's something more. But what are you thinking they can do or will do? And let's also just stipulate that the US doesn't fund any of these organizations. So this isn't a matter of the US defunding them, but what the US does, whether it is designating or standing quiet and letting them be designated, has a huge impact on what the rest of the world can do, let alone will do. So can you just sort of weigh in on that? And can you, I'm sorry, more, this is stuff you've written about. Can you talk about this whole idea of the Biden administration coming in and restoring, sanity in the rules-based international world order and respect for human rights and rule of law? How does this challenge that? I mean, because to me, this seems like a pretty direct challenge.
Yes, it is a pretty, I think, most serious challenge, I think, to their claim that the Biden administration is going to center human rights, rule of law, democracy, and support for civil society around the world, and the rules-based order that they are proclaiming to champion. This is the most serious, I think, challenge that we will see how they will act. I just want to say one thing, and just to comment on what Dima said. I think she would agree with me, but I think to make it very clear that we're not. I don't think anyone would argue that we would or we should be conceding that in free speech should be restricted under the HLP decision, and that is obviously goes into more the material support laws. Although the attempts, as Seema said, by many organizations, very conservative organizations that support Israeli efforts, have been to try to interpret the anti-terrorism laws, including material support laws in the United States, in a way that would subject organizations' legitimate activism, First Amendment protected activism, as well as speech, to these restrictions and to criminalization. So I think that although the HLP case, left a really gray area that is not helpful, we think was because of the way that scholars, civil liberties organizations, and some politicians, members of Congress, reacted to the decision. It hasn't been used in the way that it could be used potentially. For example, in the context of prosecuting or criminalizing individuals who would provide training or coordinate with the designated entities. And so I think that there's always a risk. And I think that's what they are, those organizations and interest groups are trying to pressure the government. And we saw under the Trump administration, they actually succeeded in many ways to make that by two things that they did. Particularly, I want to focus on the one related to the sanctions against the International Criminal Court, because the chief prosecutor and her deputy were designated by the US State Department and the Treasury Department as designated entities that would then be subject to sanctions by the US government. So that's happened, and that's happened to an international organization that is a multilateral organization that has a legitimacy worldwide by the closest US allies, particularly in Europe. But because of Israeli pressure, and of course pressure from certain conservative groups that did not want to see the US held accountable for the ICC, but it was really the Israeli pressure that made that sort of designation come to place. And I think that the Biden administration should be commended, even though it took them months to rescind the executive order. They should be commended by taking the right decision in terms of dropping the sanctions against the chief prosecutor and pledging, as you said, to center human rights and engagement with international organizations, including constructive engagement with the ICC. And I think it's why this is going to be a challenge for the Biden administration, because what they are offered now is kind of a deja vu of what we saw after 9/11. particularly against the Muslim American organizations that were in a very short time. About 6 organizations were designated by the Treasury Department and by unilateral and secret evidence-based process by the Bush administration. They could not defend themselves. There was serious violations of due process under the US law. And as Dima said, some people were even personally prosecuted. And there were even a larger effort to designate certain people as unindicted co-conspirators. So it went beyond the individuals who were involved in the Holy Land Foundation or a particular foundation. And it had an impact, a chilling effect, huge chilling effect on Muslim Americans and others who were engaged in humanitarian and charity efforts, particularly in the context of foreign efforts, like in support of Palestinian humanitarian causes in the West Bank and Gaza, but also in other places. So in that case, you saw the Israeli government providing the dossier and being able to, even as Dimas mentioned, Israeli Secret Service agents given the legitimacy to appear in US courts without being able to, the defendants being able to defend themselves against such evidence properly. And yet those cases went on, and we know that the assets have continued to be frozen. There were some successes. There's a case that the Kindheart case that we settled, but ultimately the chilling effect was enormous. And similarly here, we're having in a different level, obviously, because the level of the Israeli government bringing the designation, its own designations of very prominent civil society organizations, including one of the oldest human rights organizations in the Middle East, Al-Haq, and designating them and trying to have the same ripple effect on their, not only on their funding, but on all of anyone who would be associated with them, supporting them, and standing in solidarity with them. And so I think that the Biden administration have to be careful whether they would be, first of all, how do they deal with this evidence that is secret evidence? As Rabea mentioned, this secret evidence is a kind of a standard procedure in Israeli courts, not only in military courts, but in civilian courts, including before the Israeli Supreme Court, where constantly there's a pressure to see secret evidence in camera without the presence of the petitioners or the individuals involved and their lawyers. And that is a practice that's been going on for years. So that is not, the issue here is whether this dossier, which we know that is baseless, at least the one that was presented to the Europeans, and if it's not the same dossier that's presented, it has no basis, no evidence, and it's only relying on, at best, hearsay, smears and false accusations that they're trying to build a case from nothing. And so they have to be careful about the evidence and the way they do it. More importantly, they have to be careful about the consequences of whether, if they not only don't agree with the Israeli government, they will have to take a position demanding that this would be revoked, demanding that the Israeli government designation is rescinded, because if they don't take a position, an active position, that would demanding such action, it will be seen as green lighting this, or effectively coalescing with this kind of decision and giving all the lawfare organizations to the free hand to continue their effort before administrative bodies, before the agencies, before the courts. And that's exactly what the purpose of this whole thing. So they have to come very clear, rejecting this attack as a baseless attack, as illegitimate, as targeting civil society that the US government proclaimed to protect all over the world. Look, the US government is inviting Israel to participate in a summit for democracy next month, the 9th and 10th of December. There will be over 100 countries invited. Israel and Iraq are the only democracies invited to the White House for this Biden Summit for Democracy. And so there's a question. how they will be able to justify having to invite Israel as one of the two democracies in the Middle East to come to the White House when that same country is criminalizing and outlawing civil society organizations, human rights organizations, and effectively banning them from doing their work, and added to the other serious violations of human rights and international humanitarian law that we discussed earlier. The apartheid policies, the settler colonial system that's being entrenched, the blockade on Gaza, all these other violations have been that's now many of them are being investigated by the ICC. So I think that the Biden administration would do themselves a good service if they would reject that attempt, just as they did a few days ago with designating NSO, the spyware tech company, the Israeli spyware companies, as one of the listed groups or that will be banned from any communication and would be having some consequences as far as the U.S. government is concerned because of their role in repressing democratic values, democratic freedoms. That should be the direction, that rejecting what the Israeli government is doing, not just in the context of the designation, that's the first thing, but rejecting the measures that are taken against civil society actors more broadly. I mean, there are bans against travel. People can't enter Israel if they are somehow there's finding some evidence that they launched boycott campaigns. UN special rapporteurs and experts are banned from entering the country to investigate credible, violations of human rights. They banned and deported Human Rights Watch director of Israel Palestine, Omar Shakir, a couple of years ago. So there's all these things that the U.S. and the Biden administration can't just be sitting and watching while claiming at the same time that they are urging other governments, including governments like China and Russia, to play by the international rules. So the international rules mean the things that the organization have been designated as terrorist organizations have documented that are illegal. The settlements as war crimes, what is happening in Sheikh Jarrah and in East Jerusalem, the forced displacement of communities, the blockade on Gaza, and the lack of accountability for basic violations of international humanitarian law. So all of these together, I think, would really make it very difficult for the Biden administration not to do something along the lines of rejecting that designation and taking the active actions and steps in order to show their support to the work of these organizations that are regularly cited by State Department reports.
Yes, thank you. And I'm so sorry to cut in. We are running out of time. I think we have time for 2 quick answers. I want to come to Dima first. Dima, I wanted you to talk a little bit about sort of first order, second order, third order consequences, right? And Jamil has mentioned with the ICC and sanctions. Can you talk about, what the consequences are? There's people probably in this call who are not super focused on Israel, Palestine. This isn't the center of the universe. Why should they still care about this? And Rabea, we're coming to you next, so get ready. If we can be pretty quick.
Yeah, this is a critical question, right? My organization, Palestine Legal, we respond to hundreds of requests for legal help every year, and a significant portion of them are, these kinds of baseless smears, terrorism smears, as well as the kind of twin pillar of the terrorism smear, which is the anti-Semitism smear, right? And these are both intended to shut down the conversation, to distract us from the real issue, which is what Israel is and does. And so, we see this in many different forms. There is, and it's a progression from harassment and public smearing to lawfare, the kind of lawfare we've been talking about. We see online harassment and doxing, and these sites like doxing sites like Canary Mission, which are making these baseless allegations that people are, support terrorism or are pro-terrorist. And I think what kind of exposes this terrorism smear are the absurd examples. Calling Ben and Jerry's decision not to sell ice cream in occupied territory terrorism. A children's book, is terrorism. A student organizing conference is terrorism. These are common kinds of labels that are being placed on everyday activities that people are engaged in. Wearing a keffiyeh or a Free Palestine t-shirt is labeled as terrorism. So in the same way that people are constantly attacked for anything and everything they say in support of Palestinian rights, this is a cascading. It has a cascading effect, and we have clients who have been visited by the FBI after they talked about their visit to Palestine on a delegation. We have clients who Canary Mission was targeting and called the FBI, and the FBI visits them at their law school, right? And then we have deplatforming cases that I think you mentioned, Lara, Zionist groups attacking fundraising sites, claiming if you let this group fundraise on your site, you may be liable for material support for terrorism. And so these companies are risk averse, and so we see these cascading effects, starting from smears all the way to lawfare attacks, civil lawsuits like the one I mentioned against the US campaign. And so we have this perverse situation where US courts are allowing Israelis to sue Palestinians or Palestinian organizations or entities like humanitarian organizations because of these attenuated ties, alleged ties with organizations that are designated by the US government. This is while Israel faces zero accountability for its decades of oppression, its constant violations, right? So it's a very perverse situation we're in. And the fact is that we have to also understand that this as I've been saying, I think we have to look at this terrorism regime as a whole, and the terrorism label, right? It is a tool to target dissent, and we see that more and more. It has, as I've said, it undermines so many of the constitutional protections we have, but then we see it bleeding to, it's not just about Palestine, actually, right? We see Zionist efforts to call Black Lives Matter terrorist because they take a stand for Palestine, and also support the movement for Black lives. We see terrorism being used to justify surveillance at Standing Rock. We see terrorism prosecutions against animal rights and environmental rights activists. So these punishments for dissent on a number of social justice issues is being labeled as terrorism. And these are all signs that this regime is really aimed at political dissent. Just like in Israel, it's a tool to shut down political resistance. So, it's our job not only to thaw this chill that is being created and to protect people from the isolation that this is intended to create, and to defend folks and make sure that they have the courage to keep working towards freedom and justice. We also have to challenge these tactics legally, politically, in every way that we have at our disposal. We have to rally to defend not just these 6 groups for whom there, this amazing and critical international outcry has been generated, and it has to keep going. But we also have to defend the groups that are targeted here. So, I think this is a critical moment to start to interrogate what is this, what does terrorism mean, and who gets to define it, right? And and what is it intending to achieve here? It is intending to undermine our movements for a transformational change in our foreign policy and our domestic policy, and it's really a tool to crush movements, crush resistance here in Israel and globally.
Thanks. And Rabea, you're going to get the last word. And what I'm hoping you can talk about is this idea of challenging. And part of it is, what options do Palestinians have to challenge these kind of allegations or these designations? And you are part of a legal organization in Israel. I mean, what are the chances? Can Palestinians actually get any kind of justice within an Israeli court system, which appears largely to have been designed to elevate the interests of the Israeli state and a portion of its citizenry over the rights of Palestinians?
Yeah, so there is an appeal. I'll be very quick and try to capture the legal framework and the opportunities and wrap up with this. But so according to the legal framework of that 2016 Antiterror Law, there is this designation, which is considered for the first 60 days, I believe, a temporary designation, which becomes automatically after these 60 days, it becomes permanent. But there is a sort of appeal process which the committees can resort to, but the problem is it's essentially a flawed system and flawed appeal process, because there is a committee that comprises of different officials, a former Supreme Court judge, etc., but then the process in front of this committee, appeals committee, first lacks any substantive access to evidence. So even the lawyers and the committees don't have access to the evidence, all of the evidence. Some of it is secret evidence that can't be accessed. And it is up to the committee to decide whether they will give a hearing, schedule a hearing, or hold everything through writing. So there is no right to hearing. You can submit your appeal, but even then, let's say we submitted the appeal and the committee recommended that the designation would be rescinded or whatever, then the ultimate decision, and here is the main flaw, goes back to the Minister of Defense. So he has the ultimate discretion to ultimately decide whether to accept the recommendation of the appeal process or not. And we already know the intention of the minister. Now, having said that, I think there is still room for hope and action. We know that the Israeli legal system is not a just system for Palestinians, but we know that it is also responsive for international pressure. And we know that there is room to act and pressure this system. Very similarly, by the way, to the pressure we saw with the Sheikh Jarrah case. The Israeli Supreme Court eventually, which this can lead, even when the minister decides let's say not to accept the recommendation, let's say that the committee, the appeal recommendation ends with the committee concluding that this should be canceled, that the declaration should be canceled. And this is the best case, right? The best case is that the appeal committee, after the process, recommends to cancel the designation. And let's say the minister declines this recommendation. There is still a possibility to petition the Supreme Court against this decision of the minister. But we need international pressure also in this case, because we know that the Israeli Supreme Court and the Israeli legal apparatus is also responsive to international pressure. And so I think that the role of US people, of people abroad, is to continue and pressure their administrations, their governments, to demand accountability and to demand evidence to begin with, right? Like we cannot go on again with this process. And this is not a short-term battle. This is perhaps a medium term, perhaps a long term. This can take months. It's not, it will probably not end tomorrow, and we need to keep this going.
Thank you. And I made the executive decision to let this run 10 minutes over or 5 minutes over. Jamil, I know you have one last thing you want to add.
Yeah, just a couple of thoughts about the way forward as far as challenging the decision. I think we have to be remember a couple of things. One is it could be used, challenging such a decision before Israeli bodies, whether it's the committee or ultimately the Supreme Court, could be used by certain government, foreign government, particularly in the United States, to say, well, let the process play itself. Let them, they will have due process, because there's a perception that Israel does have an independent judiciary that does provide due process and does protect people's rights and organization, even from the West Bank, even under occupation. There's all these laws, all these decisions. So I think that be very careful not to fall into this trap. That is, there has to be a very principled position against the designation. It has to be a clear statement, as well as subsequent steps to make sure that these organizations are not being left to dry, and as well as others, and the consequences. And that's something that needs to be taken on. The second thing is about the way that the unity between the 6 organizations. It's important that these cases would not be divided, because could be a possible outcome of such a process, whether before the committee or ultimately before the Supreme Court, which is very much what happens in those processes, is a way of balancing the damage, the public international damage to Israel, and to what they need to do in order to give the Gans, who by the way could be a primary suspect or target of the investigation for the ICC, what they want. And that I think they could be a possibility or potential scenario where they could approve certain designation for part of the 6 organizations and deny or disapprove the others, and which would look like, oh, look, there is some due process, there is some legitimate process and that outcome is fair, and this should be accepted, and we should move forward and go back to business as usual. That should not let that happen. And that's why I think, and my proposal, a suggestion to my colleagues at Adalah was, and to the Palestinian organizations, they need to, while this process is individual organization had to challenge its individual order, but there should be a strategy not to divide the 6 in any way, and to continue to ensure that the international pressure is not waning down, is not going to weaken, because once you go into that, you lose the solidarity, you lose that. So that is what's important to happen now, to focus on making sure those governments reject the Israeli designation, reject the secret evidence, reject the baseless claims, and come forward with proactive steps and measures that show and prove that they are on the side of the human rights organizations that are being designated as terrorists. Thank you.
Thank you. And we didn't get into it, but relevant to that, I would encourage people to look at our website and listen to the podcast I did with Dawood Khattab, looking at the Mohammed Halabi case, which is a case of the employee of World Vision. The international community has been extremely deferential to Israel's due process. He has now been held on secret evidence in a secret process for 5 years, to the extent where it seems pretty clear now that he's clearly innocent, and they just don't want to let him go unless they can get some kind of plea bargain, which will let them save face. It's pretty horrific, and that sort of due process is guaranteed essentially to destroy these organizations while due process would take its course. Of course, justice delayed is justice denied here. We're going to end here. Thank you so much, Jamil. Thank you so much, Rabea, for jumping in, and Dima, as always, thank you for joining us, and thanks to everyone who joined or listened to this event. Glad to share the conversation with you, and thank you for people who gave us their questions. We worked them in as best we could. Check our website, www.fmep.org, for an entire compendium of resources. The conversation today, continually growing with new webinars and podcasts. And thank you all. Until the next time, goodbye.
Thank you.